Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes, I'm the presiding judge here in County Court at Law Number 2. This morning, you have been asked to come to court for what we call an initial appearance, or what is known as the arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious, it just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. No, sir, you need to take your hat off. Thank you. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. If the person is convicted of a state jail felony, then the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. The person is convicted of a third degree felony, the range of punishment is minimum 2 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. The person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is death. Well, the range of punishment is life in the state penitentiary without the possibility of parole, or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case. You don't have to worry about those type of punishments. Misdemeanor cases are divided into 3 categories. And we'll start at the top, work our way down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by fine only, and the fine cannot exceed $500. Now, Class C misdemeanors are cases that start in the city court or the JP court, and they come to this court after the person is convicted in that court, and they appeal their case and they get a whole new trial in this court. And the range of punishment does not change. It's still maximum fine of $500, and you cannot get into jail time. Now, if a person is convicted of a Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you can be given both such fines and fine. A person is convicted of a Class A misdemeanor. The range of punishment is minimum 0 days, 365 days in the county jail, or you can be given a fine that doesn't exceed $4,000, so you can be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation, and with the unadjudicated probation, we normally refer to it as deferred adjudicated probation. That means you do not have a conviction on your record. And if you successfully complete the probation, you will not have a conviction on your record, and you may qualify for what we call a non-disclosure. And what a non-disclosure is basically your record is sealed to the general public. So if the general public tries to go in and see this offense, they will not be able to see it because it's sealed to the general public. Now, the operative word that I've used is general public. That simply means that the government can have access to the record. Now, most of the public is general public, so most of the public cannot have access. Now, the other type of probation is called adjudicated probation. We normally refer to as regular probation. With that, you do have a conviction on your record. However, there's something that is called judicial clemency, where the court can set aside the conviction, and you will no longer have a conviction. And when I say the court, that's the judge. The judge has the discretion to set aside conviction. Now, 3 things can happen. 1, you have to successfully complete probation. 2, you cannot have more time left on probation. And 3, you have to be successfully discharged or let off the probation by the probation department. If those three things happen, then as I mentioned to you earlier, the court has the discretion to set aside the conviction. Now, if you get another conviction later on, this conviction that was set aside can be resurrected, revived, or brought back up and used against you. And if you try to get a license with CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, everyone here for the arraignment, if you're here for arraignment, you should have a clipboard. Okay? Make sure everyone have a clipboard. Okay, and on the clipboard, first of all, who does not have a clipboard? One,
I don't think she
two.
needs one.
She needs one because she
I will
has
get another
this, she
attorney,
can
that's
see
right.
this, okay. How many, one, two, what about? Two, okay,
Oh. Did you not say about one?
Oh. There.
somebody else has,
Yeah.
we didn't have enough for him. Okay, now the paperwork that's on the clipboard, I'm getting ready to go over that paperwork with you. The first document that you should see is a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. That should be the first document. The document looks like this. Okay? Now, everyone is going to, you need to have that document, get ready to go over this document with you. Everyone is going to sign, initial and sign this document. So you're gonna fall in one of the three categories, all right? First of all, it says, as a defendant in a criminal case, you have three options. That's what the first sentence says. You have three options, and the three options is regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you would like to have an attorney appointed to you, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, the first paragraph below that says that if you want an attorney to represent you, you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. Reset means we'll give you another court date to give you the time to hire an attorney. And the next paragraph says that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. Now, a financial questionnaire is another document on the clipboard. And that is a 3-page document that is titled Jefferson County Affidavit of Indigent. It looks like this. Okay, now this, if you are applying for court, if you want to apply for a court-appointed attorney, then you would have to fill out the first page of this document. And then on the second page, at the top, you will fill out the portion that is titled Defendant's Oath. And the portion down here that says unsworn declaration by defendant. All right. And this would only be filled out for individuals who will be requesting a court-appointed attorney. If you're not requesting a court-appointed attorney, you don't have to fill it out. All right. Now, the next paragraph says that you may not speak to the prosecutor unless you first sign. Now, I'm gonna give you time to go over that. I'm gonna go back over this again. Now, the next paragraph states that you may not speak to the prosecutor unless you first sign a written waiver of your right to an attorney. Now, that paragraph talks about, well, it speaks to individuals who would like to represent themselves. So if you like to represent yourself, that means you want to waive your right or give up your right to have an attorney, and you will want to represent yourself. And if you're representing yourself, you are acting as your own attorney. And because you are acting as your own attorney, you have a right to talk to one of the two prosecutors. They are assistant criminal district attorneys who work for the Jefferson County District Attorney's Office. You can talk to them to see if you can work out a plea bargain on your case. But you must first fill out the waiver of counsel. Now, the waiver of counsel is a third document on that clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. This document will only be filled out by individuals who will be waiving their right to an attorney and representing themselves. So If you would like to hire an attorney, you don't have to sign this document and you don't have to sign the affidavit. If you would like to request a court-appointed attorney, then you have to not only sign this document, but you also would have to sign this affidavit of indigence. Now, if you would like to represent yourself, then you will sign this document, the judge's explanation, and the waiver. Now, going back to the judge's explanation. Last paragraph I talked about, which is right here, that says that you may not speak to the prosecutor unless you would like to, unless you fill out a waiver. The next paragraph below that states that, and this is for individuals who would like to represent themselves. You should be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. And the last paragraph states that if you are representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. All right? Now, in bold letters, down here, where it says defendant's choice, everybody's going to make one of these choices. If your choice is to hire your own attorney, then you'll place your initials on the first line to the left. Right there, place your initials, sign and date it. That's it for you. And you don't have to sign any other documents. If you're hiring an attorney, you place your initials on this first line, and then you will sign and date it right here, and that's it. Okay? Now, if you would like to apply for a court-appointed attorney, you will place your initials on the third line to the left. And then you will sign and date it. And then you will fill out the affidavit of indigence. You'll fill out the first page, the top part of the second page that is titled Defendant's Oath, and then the middle part that says unsworn declaration by defendant. And then you'll stop. Now, if you would like to represent yourself, that is, waive your right to the attorney and represent yourself, you will place your initials on the fifth line down here to the left. Place your initials on this line and you will sign and date it. And then you will fill out the form that's titled Waiver of Counsel versus Entering Guilty Plea Proceedings Trial. So you read this and sign this. Okay, now do we have any questions? Anybody have any questions? Yes.
Okay, so if you need a court-appointed attorney, you sign your affidavit and the digits, is that just for this particular case? Does that mean like forever? Are you signing?
No, it's not forever.
It just represents.
You can't just for this case, yeah.
Okay.
Yeah, but if you have one or two cases or whatever, it's just for the case. It's for this case that's in this court at this time.
So if you represent yourself, you said it affects child support.
Oh, you should be mindful that there are dangers and disadvantages of self-representation. If you want to represent yourself, because in any criminal case, there are things that can affect things. When you get convictions and stuff, it affects benefits, whether or not you're able to go into the military services, whether or not you could possess a firearm. It can affect child custody. You might be trying to get custody of a child. And so that's what that document is saying for individual lawyers know that. Okay, but a lot of individuals do not. And so we're just making you aware that if you represent yourself, what are the possible consequences that can happen if you represent yourself that you may be unaware of.
If you get charged, if you're charged.
Well, yeah, I mean, yeah. If you're convicted, not just charged. Right. Okay, any other questions? Yes.
For the court appointed lawyer, do you have to meet a certain income requirement?
We're gonna, that's why you had an affidavit. Johnny, you can sit in there, okay. That's why you had an affidavit. We're gonna fill that out and we'll be able to determine whether or not you meet the eligibility requirements for the appointment of court appointed attorney. Okay? Any other questions? Okay, now, what we're going to do, next, you have not only do you have a right to have an attorney, but you have other rights. One of the rights that you have is a right to have a trial by jury. For example, if you say, well, I'm not gonna interfere, I want a trial by jury, you have a right to have a trial by jury. And, when this young man, Johnny, is sitting, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all of the evidence, listen to the arguments of the lawyers, and then they would deliberate in the jury room, and then they would decide whether or not to find you not guilty or guilty of your choice. You also have a right to waive or give up your right to have a trial by jury. By doing that, you would not have a trial by jury. And your case will come before the court or before the judge in one of 3 ways. One way it can come before the court or the judge is by way of a bench trial. A bench trial is a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to all of the evidence, listen to the arguments of the lawyers, apply the facts to the law, and decide whether to find you not guilty or guilty. Now, the other way that your case can come before the judge is by way of what we call an agreed plea bargain agreement. And what a plea bargain agreement is a settlement that you settled your case with the state. And the state has offered to settle your case for maybe a certain type of punishment. It could be probation, a fine, or jail time, or both. And you agree to what the state is offering. So that's an agreed punishment. And if you have an agreed punishment, it comes before the judge, and the judge can do one or 2 things. The judge can accept the plea bargain agreement or reject it. Now, if the judge rejects the agreement that you've made with the state, you have a right to take back your plea. For example, if you want to enter a plea of guilty to the charge and you reached a plea bargain agreement with the state and the judge rejects it, you can say, well, judge, I take back my plea of guilty. You have a right to do that. If the judge doesn't follow the agreement that you reached with the state. Now, if the judge follows the agreement and you decide within 30 days that you would like to appeal your case because you have a right to appeal within 30 days, so follow much from the trial, then you have to get permission from the judge to appeal your case. If you follow the agreement, then 30 days later, you say, I think I've been wrongfully convicted of judge committing an error by convicting me, I'd like to appeal my case. The judge has to give you permission. If the judge gives you permission, your case will leave this court. It will no longer be in this court, and it will go to the 9th Court of Appeals, which is right above us on the 3rd floor. There are 4 justices in that court who will review your case, and they will decide whether to grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, well, you can appeal your court to a higher court in the 9th Court of Appeals. You can appeal your court to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. And then you would have to file what is called a pro se petition for discretionary review. And what that means is you'll be petitioned, pro se means you represent yourself at that point. And you'll be petitioning them to review your case to see whether or not your appeal should have been granted, or whether or not this court committed an error, or by convicting you, or whether or not you were wrongfully convicted. They can do one of 2 things. They can grant or deny your petition. If they grant your petition again, case over. All right? They can just simply find you not guilty, or they can send the case back to the 9th Court of Appeals with orders, or send it back down to this court with orders. Okay, now if they deny your pro se petition, then at that point, your conviction will stand. Now, the other thing, the other right that you have, the other way that your case can come before the court is by way of what we call an unagreed plea bargain agreement. Let's say you and the state have talked and trying to work out a plea bargain agreement. But you can't agree on what they want, what they offer. You know, they might be saying, well, we want to give you some jail time. You say, well, I don't want no jail time. I'm not gonna take jail time. All right? I want the judge to decide what my punishment is gonna be, right? And so that will be what is called an unagreed plea bargain agreement. You don't agree with them and you want the judge to decide whether or not, you know, what your punishment will be. The judge can give you a fine, jail time and a fine, or probation, any type, you know, either unadjudicated or regular probation. Okay, all of that is in the judge's hands at that point, if you can't come to an agreement. Okay, now, the other right that you have is you have a right to have witnesses to come to court. You have a right to call witnesses in your case. They sit in that chair right there that have the microphone in front of it. We call that the witness stand. And, they can they can testify for you or against you. That means they can, and if you have an attorney, the attorney can ask them questions. Or if you represent yourself, you can ask the questions. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses that come to court. If you waive or give up your right to have witnesses come to court, that means you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in your case. Now, you also have something that's called the Fifth Amendment right against self-incrimination. That means that Fifth Amendment of the United States Constitution gives you a right, give us a right not to say anything that's incriminating against ourselves. In essence, we can't, the state, the government, the DA's office can't force us to testify against ourselves. No, a lot of times we see stories, we see shows like Law and Order. You see a person on the witness stand and one of the lawyers on television go to ask a question, they say, I take the fifth. That means I'm not saying nothing. Yeah, so you have a right not to say anything. Now, you can waive or give it up. If you waive or give it up, then you will be testifying against yourself. Now, you also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has in its file, that they be using against you. I don't know why they call it discovery. Maybe you have a right to discover the evidence, to discover what's in the file, but you have a right to see what's in the state's files, okay? And that is, you have a right to see your statements, witness statements, police reports, lab reports, video recordings. You have a right to listen to audio recordings. You have a right to see photos, documents, instruments, whatever they have. You have a right to have access to that, basically, unless it's certain things like that what their work product cannot be seen, you know, things that they have on their own. But there's for the most part, the evidence that they'll be using against you, you have a right to have access to. All right. Now, everyone that's here for the arraignment, you've been charged, you've been arrested, you've been bailed, you're out of jail on bond, you're out of jail on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of bond on a surety bond, which means you pay the bondsman a percentage of the bond to get out of jail, or you're out of jail on what we call a personal recognizance bond or a PR bond, which means you didn't have to pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear here today. Now, I've said that to say this. Every day that you spent in jail can be used as credit toward your punishment. Now, the operative word that I use is day. So, for example, let's say you was booked into jail last night at 11:59 p.m.
Still talking?
We'll talk, you know. And tell him if he's disruptive, he's gonna be held in contempt of court and put in jail. Okay, now, every day that you spent in jail can be used as credit towards your fine and court costs. Now, use every day. You was booked in jail last night at 11:59 p.m. and got out of jail at 12:01 a.m., 2 minutes later. That's 2 different days. Right? So you get credit for 2 days. Right? You don't get credit for 2 minutes, you get credit for 2 days because they're 2 different days. You don't go into 24 hours, you just they're different days. All right, now every now I say that to say this. So if you spend 5 days in jail and you talk to the state is offering you 5 days in jail, that means you don't have to do any more time in jail. Why? Because you get credit for the time that you've already served. If you spent 5 days in jail, they offer 7 days, that means you don't have to do 2 days because we will subtract 5 from the 7, that leaves 2. Now, every day that you spent in jail also can be used as credit towards your fine and court costs. You get $100 per day for every day that you spent in jail will be credited toward your fine and court costs. So you spent 5 days in jail, that's $500. State is offering you fine and court costs of $500. That's you don't have to pay it because the time that you spent in jail is already paid off, therefore it'll be taxed and retired. Now, if the state is offering fine and court costs of $700, that means you have to pay $200 because you already have 5 that you subtracted from the 7 that leaves 2. Okay. Now, if you cannot pay, now you'll be required to pay the balance on the day that we dispose of your case. If you cannot pay it, no problem, because the law allows the court to put you on what is called a payment plan. You can pay it off on small monthly installments until it's all paid off. Now, even if we put you on a payment plan, if you couldn't pay it off, no problem. Because we can convert your fine and court costs to what is called community service. Every 1 hour community service that you perform in a nonprofit organization, $12.50 will be credited toward the fine and court costs. So for example, if you work 8 hours of community service in 1 day, that's $100. So in our scenario, you work 2 8-hour days, 2 days, that's $200. So your balance will be paid off. Okay. Now, Jefferson County has a program. If you ever been in trouble before, first time getting in trouble, Jefferson County has a program where they will, and when I say Jefferson County, I'm talking the district attorney's office, they will dismiss your case and you can get it wiped off your record. Okay, the program is called pretrial diversion. Now, in order to qualify, it has to be your first time getting into trouble. Cannot be an offense for unlawful carrying weapons or resisting arrest. And you have to have an attorney to assist you with the application process. You get into the program, they dismiss the case, you complete the program, you can get it expunged, which means erased, deleted, or wiped off from your record. So for example, if it's on your record, the case gets dismissed, it's on your record look like this here. You get it expunged, it look like this. Okay, somebody go and look at your record, that's good. And here you won't have a record. You won't have this on your record. Okay, so if you're interested in that program, just let us know. And we could give you brochures and get directed to the people that you need to talk to get into that program. If you're a veteran of any one of the branches of the military service, any one of the branches, the district attorney's office has another program that is called Veterans Court. In Veterans Court, and it's for veterans only, what they will do is you get into the program, you complete the program, they will dismiss your case. Once you complete the program. And then you can get a non-disclosure. Non-disclosure is, as I mentioned to you, your record is sealed to the general public. All right, it's for veterans only. Now, this court, county court at law number 2, has a program that is called Community Safety Initiative, or the CSI program. It's a program that God led me to start within the first 100 days of taking office in March of 2017. The program is designed to address the issue of what we call recidivism. Recidivism just simply means that people commit crimes over and over. And so how do we stop it? Well, with this program, our Community Safety Initiative, we have partnerships with various agencies in our community. And one of the agencies that we have a partnership with is Spinotop. Spinotop is our local mental health authority in the Southeast Texas region. And what they have the expertise to address any mental health needs that a person may have. Now, in order to participate in a program, you do not have to be incompetent or insane. You could merely suffer from anxiety or depression or any other host of mental illness, and they have the expertise to address your mental health needs. Now, what they will do, first of all, they can have a private interview either in our jury room, in our, at their facility or by telephone, whichever is convenient for you. They will also be able to do an assessment to determine what your mental health needs are, and they can develop a treatment plan to address your mental health needs. And the treatment plan could be the outpatient or inpatient treatment. If you have issues with drugs or alcohol, okay? Well, they have a program at Spillertop that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. We also have a partnership with with our local drug and alcohol council that has a program that is called ATAR, which is an acronym, ATAR, that stands for, they have a program that is called OSAR, OSAR, that stands for Outreach, Screening, Assessment, Referral. Both of those programs are drug and alcohol recovery programs. And what they will do a screening, an assessment, and they can develop a treatment plan for either outpatient or inpatient to address your alcohol or drug problems. If you are unemployed, or you just might be looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. It stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. If you have not graduated from high school or you do not have your GED, they have a GED program where you can get your GED. Now, in order to participate in all of these programs, they are free. Does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. And that simply means that we do not arrest the problem, we address the problem. And we believe that if we address the problem, we produce productive people. We produce productive people will not commit crime. Why? Because they have too much to lose. So I like to say that when you come to county court at law number 2, we do not have just court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before the court. And if we make a difference in their life, then we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know, and we'll be able to point you in the right direction so that you can get whatever needs you have addressed. Now, at this time, I mentioned to you earlier, we have some folks from Spindletop. We have Caitlin and Deputy Barry. They're going to come to you right now and tell you a little bit more about the program that Spindletop has to offer. Deputy Barry and Caitlin.
Good morning, ladies and gentlemen. My name is Patricia Berry, and I am a deputy with Jefferson County Sheriff's Office. Also a mental health liaison for the last 7 years. My partner Caitlin here is a qualified mental health professional in the Spindletop services. Now, the reason that we're here today is because the judge cares about each and every person that enters the school. And we've found statistically that people who enter the criminal justice system often have mental health needs that are not being met, or possibly substance use issues, or maybe just the lack of resources. So that's what we're here to provide you with today. And the first way we're going to do that is there's a piece of paper on the front of that clipboard. Short piece of paper, just like this one right here. Ms. Caitlin is going to give you information on how to fill this out. This is a voluntary, paper. We don't have to fill it out if you choose not to. All right, this is not mandated by the court. This is simply something for us to give to you to say, hey, we're here if you need us. If you need resources, that's what we're here for. We can provide them to you. And Ms. Caitlin's gonna talk a little bit more about, how you can contact us or how we can contact you as well.
At the top of the paper is your basic information, your name, your birthday, email, phone number. We need these things to put you in our system and to be able to contact you. Under that is how would you like to be contacted, and the options are call, text, or email. Whatever you check is how we will contact you. I will not contact you unless it's checked in one of those boxes. Under that is resources that you would like help with, and most of them is if you check the box, I'll email you or text you forms or a link or a website, and you have to do it yourself. But if you were to check mental health, which can be depression, anxiety, PTSD, or drug or substance use, which can be any type of drug or alcohol, and you can work with Top, where we can get you the services, the support, and the resources that you need to battle it. Everything else is pretty much self-explanatory. If you'd like to talk to me in person, then you can write anywhere on your paper, please talk to me in person. And when it's done with you, I will bring you to the back, like you said earlier, and we can talk, you can talk to me, you can talk to Officer Berry, wherever you prefer. If you would like for me to call you today, you can write on your paper, please call me today. It doesn't matter when I come in contact with you, then you can just check the box and I'll get to you sometime. Yes, I can give one. We'll get one too.
Now, once again, this is voluntary. You do not have to fill this out. This is just simply a way of us being able to provide you with more resources. And even if you don't need this resource, but you know somebody who does, please pass this information on. So the first resource we're going to give you today is we're going to go around and pass out business cards. These business cards are simply on the back of it. It has a crisis hotline number. Crisis hotline number is 24 hours a day, 7 days a week. Somebody will answer your call. Please feel free to also give this number out. Thank you.
Yeah, he's here.
If you have any questions.
Murphy? Yeah, he's on the jail run document. Yeah, okay, ladies and gentlemen, at this time we have Johnny, who on Family Services, is gonna tell you about the Batters Intervention and Prevention Program, which is also part of the pretrial diversion program. Johnny?
All right, thank you, Judge. Good morning. I'm Johnny Stewart. I'm with Family Services of Southeast Texas. Family Services also have the emergency shelter, but we also have different programs. The Batteries Intervention and Prevention Program used to be called the Domestic Violence Program. But it's now the Batteries Intervention and Prevention Program. This is an 18-week program, and it's part of the pretrial diversion program. And if you had a charge of family of violence or family assault, this is one of the programs that's offered to you. We have the in-person groups, and we also have for the guys who are working, you know, a lot of them work out of town, maybe work at the plants. We have a Zoom class also. So it's 18 weeks, you complete this program, you will satisfy the conditions of the courts. So, if you've been involved, if your case involved domestic violence, family violence, this program is offered to you. It's called the Batteries Intervention and Prevention Program, and it's with Family Services in Southeast Texas. Thank you very much.
Okay. Okay, ladies.
Thank you, Judge.
All right, thank you, guys. Ladies and gentlemen, we're getting ready to go into a break. And that'll give you time to fill out the paperwork. If you need any help filling out the paperwork, we have our four person here, including myself, who will be happy to assist you at filling the paperwork out. Now, this is gonna, once you fill out the paperwork, we're gonna pick the paperwork up, and then we're gonna call you one at a time to come before the bench. And then we're going to put you in one of three categories, whether or not you want to hire an attorney, whether or not you want to put up an attorney, or whether or not you want to represent yourself. Now, this is gonna take us a little time. If you need to use the restrooms, there are two restrooms just right outside in the hallway. The men's restroom is in front of county court number 3, which is right next door. And the women's restroom is on the opposite side of the hall. in front of the 172nd District Court. You'll be allowed to go out in the hallway, use the restroom. Please do not leave the courthouse. If you leave the courthouse, your name is called, you're not here, your bond can be forfeited. If your bond is forfeited, a warrant issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. We'll have to go through this process all over again. Okay? So, at this time, the court is going to go into recess. Now, be mindful that we're still in court. Okay, so conduct yourself accordingly. The court is going to go into recess. And, again, if you need some help, we'll get ready, just raise your hand and we'll call you up. So we'll have some people come out to you and help you, okay? Then we'll start picking up the paper. Who all needs, help with the paperwork? Do you have my gloves over there? Charlie, no, speech. You have a pen? Thank you. Thank you. Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases. Cause numbers 24 CCCR 0996 and cause number 24 CCCR 1165. Both cases are styled the state of Texas versus Monesia J. Holmes. Ms. Holmes, is that your full name? Ms. Holmes, would you please raise your right hand? Holmes, do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing? I'm doing fine, thanks for asking. So if you're represented in your case by your attorney, Attorney Charles Rojas. Attorney Rojas, how are you doing?
Doing well, Judge, thank you.
And Mr. Rojas, did you waive a record in Ms. Holmes' case?
We do.
And the state is represented in this case by Attorney Haley Simmons. Ms. Simmons, how are you doing?
I'm great, Judge, thank you.
Ms. Holmes, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Marnesia J. Holmes, on or about March 17th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault family violence. Ms. Holmes, do you understand what you've been charged with? Assault family violence? Yeah, it was assault on a family member?
Oh, okay, yes, sir, yeah, yeah.
Okay. And to this charge, how do you plead? Guilty, not guilty, or no contest?
Yes, sir.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty? I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials MH on the line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature? On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document. And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
It needs to be signed. And Ms. Holmes, before you signed and initialed all of the documents that I just showed you, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Holmes, are you a citizen of the United States?
Yes, sir.
State Officer States 1.
No objection.
No objection. States Exhibit Number 1 will be admitted. Mr. Rojas, you advised that counsel, Ms. Holmes, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Holmes, your attorney, Mr. Rojas, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Ms. Holmes, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt statement. Do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 2 years deferred probation, fine is to be waived, 60 hours community service, no contact with the complaining witness, Desiree Sanchez. This is running concurrent with felony clause number 24D CCCR 0878 and clause fitting in 0879, and we're dismissing the companion case.
Okay. What is the courthouse?
$277.
It's a $100 fee to the Crime,
Yes.
Family Violence Center. And, now, what you said was the courthouse,
277.
277. Okay, so she's already on probation.
You need those call numbers again, Judge, or you have them?
I have. Okay. Ms. Holmes, the state is offering that you serve 2 years deferred adjudicated probation. During this 2-year probationary period, you will not be required to pay a fine. In this case, the fine is waived. You will be required to pay court costs of $277. You'll be required to pay a $100 fee to a family violence center in our area. You'll be required to pay probation fee of $6 a month. You're now subsidy $15 a month, reimbursement fee of $15. That total monthly installments is $95. However, since you are already on probation, the probation fee of $60 a month will be waived. And, well, you'll not be required to pay it because you paid it in the other case. And the analysis fee that you were required to pay in this case will not be paid because you paid it in the other case. And so therefore, your probation fees each month will be $17 a month in this case. Will you be able to pay the $17 each month? You will also be required to perform 60 hours of community service. And you cannot have any contact with the victim, in this case, Desiree Sanchez. This case will run concurrent with cause numbers 24DCCR 0878 and cause number 24DCCR 0879. And the state will be dismissing the companion case, cause number 24CCCR 1165. Ms. Holmes, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Ms. Holmes, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Ms. Holmes, you will stand at the end of that table, follow the directions of the bailiff. Once you're finished following the directions of the bailiff, you can follow the bailiff. You have a blessed day. Now, if you do not have anything else holding you in jail, you should be getting out of jail today. Okay? Oh, and when you finish printing her, I need to go over her admonition with her. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or carry firearm manufactured before 1899, or two, a replica of an antique or carry firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your inability to possess a firearm or ammunition lasts, the court recommends you contact an attorney. For reference, you may wish to consult the statutes listed below, which may or may not apply to your circumstances. Code of Criminal Procedure, Article 17.292, Master's Orders for Emergency Protection. Code of Criminal Procedure, Article 27.14E1, plea of guilty or nolo contendere in a misdemeanor case. Code of Criminal Procedure, Article 42.0131, notice of persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, unlawful carrying weapons. Penal Code Section 46.04, unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders and conditions of bond in a family violence, child abuse and neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code 85.026, warning on protective order. Now, the written admonition that's been handed out to you is for your records. You can follow the bailiff, and you have a blessed day.
Excuse us.
Yes, Mr. Ross, you may be excused. Okay, when I call your name, please come before the bench. Cameron Dennings. Okay. Let's see, this is call number 25 CCCR 0418. Case is style of state of Texas. The case is style of Cameron. Who's that? Joedna? Your middle name? Okay, Cameron Joedna Dennings. Ms. Dennings, is that your full name?
Yes.
How are you doing, Ms. Dennings? Okay, Ms. Dennings, would you please raise your right hand? Ms. Dennings, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Dennings, you may put your hand down. Ms. Dennings, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Jennings, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Jennings, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you. You will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Cornelius Lewis. Mr. Lewis, your full name is Cornelius M. Lewis? Yes. Mr. Lewis, would you please raise your right hand? Mr. Lewis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Lewis, you may put your hand down. How are you doing, Mr. Lewis? I'm doing fine, thanks for asking. Mr. Lewis, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document or in the middle of this document, there's some initials on a line that states that you like to apply for court-appointed
Yes, sir.
attorney. Is that correct?
Yes, sir.
I also have another document that is titled Misdemeanor Plea Admonishment. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is that your signature?
Yes, sir.
Now, Mr. Lewis, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Lewis, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney that will be appointed to represent you in this case is Attorney Laura Perazzo. Attorney Perazzo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once you get that information, you'll be free to go and you have a blessed day. Please have a seat in that second chair on the wall. Harry Dukas. Okay, Mr. Dugas, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth shall help you God? Mr. Dugas, you may put your hand down. Now, Mr. Dugas, we have two cases. Cause numbers 25 CCCR 0240 and cause number 25 CCCR 0243. Both cases are styled the state of Texas versus Harry James Dugas. Mr. Dugas, is that your full name? Mr. Dugas, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you'd like to apply for a court-appointed attorney? Now, Mr. Dugas, I also have another document before me that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. This is your signature. Okay, Mr. Dugas, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Dugas, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will also be given information to contact him. And our court coordinator will give you that information, but before she gives you that information, I need to give you some bond conditions. Our bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title? And it states that following the return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number one, defendant shall commit no offense against the laws of this state, any other state of the United States. Do you understand that condition? Condition number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? Now, condition number three does not apply in this case, and condition number four does not apply either. However, condition number five does apply. Condition number five states that the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that? Now, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Please have a seat in that first chair on the wall and wait for your name to be called. Leonce Robert Monroe Jr. Okay, Mr. Monroe, your full name is Leonce Robert Monroe Jr.?
Yes.
Okay, Mr. Monroe, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Monroe? That's good. Mr. Monroe, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled
Yes.
defendant? Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of this same document, there's a signature above the line that's titled Defendant Signatures. That's your signature.
Yes.
Now, Mr. Monroe, before you sign and initial these documents, did you read the documents?
That's my knowledge.
Okay, did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Mr. Monroe, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Marva Provo. Attorney Provo will give information to contact you. You will also be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in the second chair on the wall. Lilia Britt. Ms. Britt, your full name is Leah Shea Britt. Ms. Britt, would you please raise your right hand? Swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Ms. Britt, you may put your hand down. How are you doing, Ms. Britt? That's good. Now, Ms. Britt, I have two documents before me. The first document is titled Judge's Explanation of Rights and Defense Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendants?
Yes, it is.
And are these your initials on the line that state you'd like to apply
Yes.
for a court-appointed attorney? I also have another document before me. This document is titled Jefferson County Affidavit.
Yeah.
I don't, where's the motion? Okay, whose phone is going off? Now, on yesterday, you appeared in court and your attorney of record at that time, was, Alan Parker. And Mr. Parker had filed a motion to withdraw the case, is that correct?
Yes, sir.
And you did not have any objections to that motion, is that correct?
I don't, I'm,
My question was, at that time, did you have any objections to that question yesterday? Okay, now, oh, you have objections now? That's what you're saying?
no, sir, I just, the paperwork says that it was so I could choose a different lawyer, but that's not what happened. Because I couldn't, because the person who agreed to pay stopped paying.
Okay, now, the motion that the defendant agrees to withdraw, the cause withdrawal funds field from filed obligation is not sought to delay continued representation. Withdrawal would not be adverse effect depending setting offense to all relief from the motion in the motion. Much for hearing. Agree to this withdrawal. And this is your signature on this document, right? That said you agree to the withdrawal. Okay. Record to that.
I don't know if I have a choice, right? And if I can't pay him, he can't. And he's.
Choice. On yesterday, I asked you, if I asked the question that you object to the motion or you did not object, that's, you have a choice. You gotta, your choice is to object or not object. You did have a choice. Okay, so let me ask you this here. So what is your, before we go any further, we have a motion to withdraw that was filed by attorney Alan Parker. And in this motion to withdraw, there's a signature that you identified as your signature. And is below a statement that says, I, Leah Chase Britt, agree to this withdrawal of attorney. So my question to you is that, are you agreeing to the withdrawal or are you not agreeing to the withdrawal?
I agree.
Okay, so you agree, okay. So, and as a defendant in a criminal case, during arraignment, I mentioned to you, you have three options. One option is you can hire an attorney. Second option is you may request a court-appointed attorney. And the third option is you may represent yourself. Now, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. And it has a signature on the line that's titled Defendant, this your signature.
Yes, sir.
And it has a set of initials on the line that says, I want to apply for a court-appointed attorney. And that's your desire.
Yes, sir.
Okay. I also have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2, there's a signature above the line that is titled Defendant. Is this your signature?
Yes.
Now, before you sign and initial these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Think so, yes.
Okay,
Yes.
you say, okay, did you understand what you read or not? If you didn't understand, I'll give you the documents
No,
back
sir,
and
I
give you,
understand.
you can go back over it. Okay. Now, is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, now, Ms. Britt, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your cases is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. Our court, that door is locked, sir. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. and you have a blessed day. You can have a seat in that first chair on the wall and wait for your name to be called. Yeah. Sarah Roy. Ms. Roy, your full name is Sarah Renee Roy?
That is my maiden name. My married name is Tatum.
Okay. Would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God? You may put your hand down. How are you doing?
Good.
That's good. Now, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes.
On page 2 of this same document, there's a set of initials, there are a set of initials. Well, actually, there's a signature on the line that is titled Defendant Signature. Is this your signature? Ms. Roy, before you signed and initialed these documents, did you read the documents? Did you understand what you read?
Yes.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Ms. Roy, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that is appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get that information, you're free to go. And you have a blessed day. Please have a seat in that second chair on the wall. You're welcome. Oh, what's, uh-oh. Is she in here?
He.
He,
Something.
Shaniqua Washington? Ms. Washington, your full name is Shaniqua Diana Washington. Please raise your right hand. Swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God. You may put your hand down. How are you doing, Ms. Washington? I'm doing fine, thanks for asking, Ms. Washington. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? Yes, and is this are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Ms. Washington, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Washington, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. Attorney that's appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. What is that? Dylan Pachuca? Mr. Pachuca, Is that how you pronounce your last name?
Pachuca, yes, sir.
Okay, Mr. Pachuca. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Pachuca, before you sign and initial these documents, did you read the documents?
Yes, sir.
You understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Hey, Mr. Pachuca, I read your answers. Based on your answers, I don't think you don't meet the eligibility requirements for the appointment of a court-appointed attorney. So at this point, you have two other options. You can either represent yourself, waive your right to attorney, represent yourself, or you can have your case reset so that you can hire your own attorney. Do you understand?
Yes, sir.
Okay, Ms. Mosby, could you hand this document back to him? You can make your choice. Okay, so he has to, we need to give him a waiver to fill out. It should be on the clipboard, last document. She's gonna give you a waiver that you can read and sign. You can have a seat in that chair, the table. And you can fill that document out. When you finish, we'll call you back up. Jennifer is not available. Okay, Davion Lewis,
That's for,
who was that for?
that's for him.
For who? Lewis?
Or, no. Corbin.
Oh. Where's the rest of the paperwork? The rest of it must have fell down.
No.
This is just an affidavit. Where's the judge's explanation?
You should already have it.
It all fell. So what I'm saying is, it might be down on the
No,
floor.
because he already did paperwork. He wanted to represent himself, so that's. Yeah,
Oh, up here, okay.
Yeah.
Okay, now, Mr. Lewis, your full name is Davion. Davion Latrell Lewis. Mr. Lewis, would you please raise your right hand? Mr. Lewis, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Mr. Lewis, you may put your hand down. How are you doing, Mr. Lewis?
Great.
Good, fine, thanks for asking. Now, Mr. Lewis, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or these your initials on the line that state you like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Lewis, before you signed and initialed all of these documents, did you read the documents?
Yes,
Did you understand what you read?
yes,
Is everything in these documents true and correct to the best of your knowledge?
yes,
Mr. Lewis, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you, in this case, Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will give information to contact him. Our court coordinator will give you that information. Once she gives you the information, you'll be free to go. And you have a blessed day. Now, before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over this document with you. And it states, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, Defendant shall commit no offense against the laws of this state, any other state or the United States. Do you understand that condition?
Yes, Your Honor.
Condition number 2, the defendant shall submit to testing drugs and alcohol at any time. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test of drugs and alcohol when directed to do so by the court, or B, submit to test of drugs and alcohol. The test in the case of presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 and 4 do not apply. Condition number 5 does apply. Condition number 5 states defendant is prohibited from possessing a firearm ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Mr. Lewis, do you understand that condition?
Yes, Your Honor.
Now, Mr. Lewis, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Please have a seat in that first chair on the wall. Wait for your name to be called. We have any pleas ready? Dick Knox. What about Holloway? I got, you say Knox and Young? His is Rainy. And I have Holloway. You said Knox and Young?
Yes, Patrick.
Jay Knox? Oh, okay. This is cause number 25 CCCR 0198. Case is style of state of Texas versus Jay Knox. Mr. Knox, is that your full name?
Yes, Your Honor.
Mr. Knox, would you please raise your right hand? Mr. Knox, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Knox, you may put your hand down. How are you doing, Mr. Knox? I'm doing fine, thanks for asking. Now, Mr. Knox, you have a right to have a court reporter type down everything that we say in court in this case. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up the right to have a court reporter? Okay, now, Mr. Knox, I also have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant? Or these your initials on the line that state you'd like to apply, well, that you would like to represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Is this your signature?
Yes, sir.
Now, before you signed and initialed all these documents that I just showed you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Knox, I also have before me a document on my computer that is titled misdemeanor, well, actually it's titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jay Knox, on or about October 23rd of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Knox, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Knox, how do you plead? Guilty, not guilty, or no contest?
Contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Knox, I also have before me on my tablet a document that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials or two sets of initials. First set of initials is below a paragraph that is titled waiver. And it is, these initials are on a line next to a box that's checked guilty. Did you place your initials on a box that's checked no contendere, which means no contest? Did you place your initials on this document? The second set of initials is below a paragraph that is titled discovery admonishment. And it is next to a statement that reads, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document? Now, Mr. Knox, before you sign and initial these documents, did you read these documents?
Yes, sir.
And is everything in these, did you understand what you read?
Yes,
Everything in these documents true and correct to the best of your knowledge?
yes, sir.
Mr. Knox, are you a citizen of the United States?
Yes, sir.
State offer states one.
Now, Mr. Knox, the state is offering State's Exhibit Number 1 to be used as evidence in your case. State's Exhibit Number 1 is the first document that I showed you on the tablet. This is the same document that have your initials in these two locations. And it has your signature on the third page. Is it all right for the state to use this document as evidence in your case? No objection. State's Exhibit Number 1 will be admitted. Mr. Knox, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay. Mr. Knox, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 5 days in the Jefferson County Jail, credit for 5 days, and a tax and retire all court costs.
Mr. Knox, the state is offering that you serve 5 days in Jefferson County Jail, but you would not be required to serve any more time in the Jefferson County Jail because you already served 5 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Knox, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer? Mr. Knox, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Knox, you'll stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day.
Yeah.
You're welcome. Now, Mr. Knox, is this the gentleman? You need to come back up. You had, let me do this here. Okay, this is cause number 25 CCCR 0428 case of style of state of Texas versus Ignacio Gomez. And Mr. Gomez speaks Spanish. We have our Spanish interpreter, Ms. Jennifer Rogers. Mr. Rogers, would you please raise your right hand? Do you swear to interpret Spanish to English and English to Spanish to help you God?
Yes, sir.
You may put your hand down. Ask Mr. Ignacio Gomez if his full name is Ignacio Gomez.
Yes, sir.
Yes, Judge.
Okay, tell him to raise his right hand. Mr. Gomez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can tell him, you can put his hand down. Mr. Gomez, how are you doing? Bien?
Good.
Good. Now, Mr. Gomez, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Ask him if he recognizes this document.
Yes,
And
sir.
ask him if this is his signature on the line that's titled Defendant.
Yes, eso firma ahí completo.
Yes.
And then you can also ask him if, are these his initials on the line that states he would like to apply for court-appointed attorney.
Yes.
I have another document that is titled Jefferson County Affidavit of Injuries. Ask him if he recognized this document.
Yes, yes.
And you could ask him if this is his signature on the line that's titled Defendant.
Yes, eso firma completo.
Yes.
Yes, Judge.
Okay, now, ask him if, before he signed and initialed these documents, if you, Mr. Raji, went over these documents with him in Spanish.
Same.
Yes, Judge.
And ask him if he understood everything that you went over.
Yes, Judge.
And is everything in these documents true and correct to the best of his knowledge?
Yes, Judge.
Okay. Now, Mr. Gomez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you, in this case, is Attorney Charles Rojas. He speaks Spanish. Okay. You can tell him he can stand over in front of the court coordinator, get his reset. Okay, thank you, Mr. Rogers.
You're welcome, Judge.
And Murphy,
Does he want to reset it for transfer?
What are you talking about?
the one that Brittany was on for all the felonies, he's in custody in the back, and he'd be brought back to the jail.
Yeah.
Jacoby Murphy.
Yeah, I don't, his lawyer is not here.
Oh, Rennick, it was, Rennick came in this morning.
Yeah, he came in this morning, but it was the case was gonna have to be transferred for conflict. Okay, what about, let me see, Holloway. Patrick Young? Okay. This is cause number 25 CCCR 0334. Case is style of state of Texas versus Patrick Young III. Mr. Young, is that your full name? Mr. Young, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Young, you may put your hand out. How are you doing, Mr. Young? That's good. Now, Mr. Young, I have before me. Well, before we get started, Mr. Young, you have a right to have a record made. That simply means you have a right to have a court reporter to type down everything that's being said in your proceeding. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes, sir.
Okay, now, Mr. Young, I also have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Young, before you sign any initial, all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Young, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Patrick Young III, on or about December 21st of 2024, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of resisting arrest. Mr. Young, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Young, how do you plead? Guilty, not guilty, or no contest?
No contest.
Or you pleading no contest freely and voluntarily?
Freely.
And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means.
I just wish to not contest.
Okay, now, Mr. Young, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
No, sir.
You don't recognize this document? Let me do this here. There's some initials in two locations. You would hand the document to them. There are some initials and on the second page of that document. First set of initials is below a paragraph that is titled Waiver. And the first set of initials are on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on that document?
Yes, sir.
The second set of initials is below a paragraph that is titled Discovery Admonishment. And it is, those initials are next to a statement that states, I do not request discovery of the evidence. I waive my right to discover the evidence in this case and choose to enter a plea of guilty or no contest. Did you place your initials on that
Yes, sir.
line? Okay, go to the next page. On the next page, there's a signature above the line that is titled Defendant. Is that your signature?
Yes, sir.
And on the next document, is there another? Okay, on the next document, the document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize that document?
Yes, sir.
Is that your signature above the line that's titled Defendant?
Yes, sir.
At the top of this document, or at the top of that document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir. I understand.
And the second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Okay. Now, before you sign and initial all of those documents that you just acknowledge on this tablet? Did you read the documents? Did you read these documents before you signed and initial them?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Young. State.
State upper state's one, Your Honor.
Okay, now state is offering state's exhibit number 1 to be used as evidence in this case. State's exhibit number 1, go back to this first document, because that is state's exhibit number 1, it's the same document that you acknowledge, same document that have your initials in these 2 locations, and it has your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Now, Mr. Young, are you a citizen of the United States?
Yes, sir.
Okay, state's exhibit number 1 will be admitted. Now, Mr. Young, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Mr. Young, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. The state, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 1 year deferred probation, $200 fine, 30 hours community service and court costs. And the defendant does have 6 days and the Jefferson County Jail will be accrediting to the fine and court cost. It should be on there.
Yeah, say 6 days credit. What's the court cost? Okay, let's just go 0 out. That's gonna be 0. Okay. Okay, Mr. Young, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $200 plus court costs of $277. You will be required to pay a probation fee of $6 a month, your analysis fee of $15 a month, reimbursement fee of $15. You have 6 days credit that will be credited toward your fine and court costs, which means that the fine and court costs is already paid. Okay. Now, here it is. So instead of being required to pay $127 a month, you have to fine the court costs, the probation fee $6 a month, the $15 for a year analysis fee, and the $15 reimbursement fee. You'll be required to pay $83 a month. Are you able to pay the $83 each month? Or you hesitate, so you must not be able to pay it, I mean.
I'll be looking to get a job.
Well, okay, so you don't have a job.
Nothing.
Okay. Okay, we need to give you an affidavit of indigence. She's gonna give you the affidavit of indigence. And that document will have your financial information on it. And I'm gonna review that, and then we'll take it from there. Okay. So have a seat in that chair right there. And she's gonna give you the paperwork and the pen. Just have him to fill out the bottom portion, put his name, and have him fill out that. You can tell him what to fill out. Now, what you need to do, don't leave anything blank. If you don't have, for example, you don't have the income, it will be 0. If you don't have like your bills, like they say, if you have to pay like a rent or food or whatever, if you have to put that, you put that what you pay per month. If you don't have it, it's 0. If you're not paying it, you understand what I'm saying? All right. So just take a few minutes and fill that document out right quick.
That is the first page, you want this and.
No, I just need his affidavit. That portion I need to get his financial information on it. You did? And we'll come back to him. I'm gonna send this back to you, but you need to send it back to me, his document, so I can do that other.
Okay.
Let's see, let's put you. Mr. Pachuca. Mr. Pachuca. Would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? That's right. Mr. Pachuca, you may put your hand down. Mr. Pachuca, your full name is Dylan, let's see, is Dylan Joseph Pachuca?
Yes, sir.
How are you doing, Mr. Pachuca?
I'm doing pretty good. How about you?
All right, now did I swear you in? Yeah. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
That's right.
All right. Now, Mr. Pachuca, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorneys. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to waive your right to attorney and represent yourself?
Yes, sir.
I also have a document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceedings Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Pachuca, before you signed and initial these documents, did you read the documents?
Yes, sir.
You understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Hey, Mr. Pachuca, I have before me on my computer a document that is titled misdemeanor plea admonishments. Well, actually, the document is titled information. In this information, it alleges that you, Dylan Joseph Pachuca, on or about December 4th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Mr. Pachuca, do you understand what you've been charged with?
Yes,
To this charge, Mr. Pachuca, how do you plead? Guilty, not guilty, no contest?
no contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir. No.
Mr. Pachuca, I also have before me a document that is titled misdemeanor plea admonishment. Do you recognize this document?
Yes.
On page 2 of the same document, there's a set of initials. First set of initials is the lower paragraph that's titled waivers, and they're on a line next to a box that's checked no contingent, which means no contest. Did you place your initials on this document?
Yes.
Second set of initials is below a paragraph that is titled discovery admonishment, and the initials are on a line next to a statement that reads, I do not request discovery of the evidence. I waive my right to discover evidence in this case and choose to enter a plea of guilty and no contest. Did you place your initials in this location as well?
Yes.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes.
And on the next document is titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case. You have no right to appeal. You understand this statement?
Yes.
Second box that checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Now, Mr. Pachuca, before I go any further, you have a right to have a court reporter to dictate everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
No, wait.
Okay.
Give me the right.
Now, Mr. Pachuca, again, before you signed and initialed all of these documents, you read these documents, is that correct?
Yes.
You understood what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
And Mr. Pachuca, are you a citizen of the United States?
Yes.
State offer states one.
Now, Mr. Pachuca, the state is offering State's Exhibit 1 to be used as evidence against you in your case. State's Exhibit number 1 is the first document that I showed you on the tablet, same document that have your initials in these 2 locations. And it has a signature above the line that's titled defendant. Is it all right for the state to use this document as evidence in your case?
Yes.
Okay, no objection, State's Exhibit number 1, we admit it. Mr. Pachuca, are you a citizen of the United States?
Yes.
And, okay, Mr. Pachuca, I will accept your plea of no contest. I will find that you're mentally competent to stand trial. I will also find that your plea and waivers are freely and voluntarily given. I also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
In exchange for defendant's plea, the state's offering 90 days probated over 1 year, $300 fine, 40 hours community service. That class, there is 2 days of credit that will be accredited to the jail time.
2 days.
Fine.
$40 community service. 2 days credit. What is this court cost? $277. So 577, that'd be $377. Okay, Mr. Pachuca, the state is offering that you serve 90 days in Jefferson County Jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. You'll also be required to pay probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments will be $136 a month. Now, the state is giving you credit for the 2 days that you've already spent in jail. So instead of paying the $136 a month, we'll take the $200 off the total, and that you'll be required to pay $117 a month. Will you be able to pay the $117 each month?
Yes, sir.
You'll also be required to perform 40 hours of community service, attend a completed deaf class, and you'll be required to adhere to the other standard terms and conditions of this probation. Mr. Pachuca, do you understand the state's offer?
Yes, sir.
You think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Pachuca, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Pachuca, you can stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day. You're welcome. Patrick Young. We have some tea. That's right. Oh, Young. Is this it?
Yes, sir.
Okay. Okay, Mr. Young, you was previously sworn in, is that correct? We swore you in to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Now, I have before me a document that is titled Jefferson County Affidavit Engine. You recognize this document?
Yes, sir.
On page 2 of the same document. Well, now, Mr. Young, before you sign this document, did you read the document?
Yes,
Did you understand what you read?
yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Young, the court have read your answers. The court will find that you're indigent. Based on the finding of indigency pursuant to Article, let's see, 102.018 of the Texas Code of Criminal Procedure, the $15 administrative costs will be waived, which means you won't have to pay it. And the court costs or the probation fee of $60 will be reduced to the statutory minimum of $25 a month. And you'll be required to pay the year analysis fee of $15 a month. So your total monthly installments, instead of being the $127 a month or the $83 a month, is $44 a month. Okay, so you'll be able to pay the $44 a month.
Yes, sir.
Okay. Now, Mr. Young, do you understand the state's offer and the court's adjustments? The adjustments that I made to the your payments?
Yes, sir.
And do you think that is fair and just?
Yes, sir.
And do you accept it?
Yes, sir.
Okay, now, Mr. Young, I'll follow the plea bargaining agreement with the court's adjustments. In this case, and Mr. Young, if you successfully complete this probationary period, this case will not result in a conviction on your record, and you may qualify for a non-disclosure whereby your record will be sealed to the general public. You can talk to an attorney about that matter, okay? Now, Mr. Young, I see that, first of all, Mr. Young, how old are you?
19.
19, okay. Now, I see that you're not here alone. You have some people here with you. Is that correct?
Yes, sir.
And who are here?
Terrence.
Your parents, okay. Thanks for coming down here with your son. Now, Mr. Young, I do know, I'm glad you said your last name is Young because I was getting ready to say that. I used to be young at one time. Believe it or not, I had hair on my head, okay? That was many, many moons ago, okay? I was 19 for 365 days, okay? And I know young people today, we put a lot of stock into our friends, okay? I think y'all call them your BFFs, you know, best friends for life. You say that these people will be with me through thick and thin, my ride and die, okay? But on days like today, when you need a friend, okay, that friend that's gonna stick with you through thick and thin, guess what? They had other things to do. They're not here for you. But I see some people that's here for you who probably put aside some very important stuff that they had, but they came here for you. Okay. And you know why they did that? That's right. They love you. They're your friends. That's the ones who put a roof over your head. None of your friends put a roof over your head, put clothes on your back, put food on your table, but they did. And they sacrificed their time to come down here for you. Okay. Now, this is not the proudest day in their life. Okay. But, it might be a storm. You might think it's a storm going on in your life. But remember this, when you're walking through a storm, hold your head high and don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of a lark. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope and hope in your heart, and you never walk alone. Some people might look at this as a stumbling block, but you could look at it as a stepping stone. A stepping stone is what people use to reach higher heights. Okay? And so you can put this all behind you. Okay? You don't have to, this is not your current situation is not your destination. Okay? This is only the beginning. Okay? You keep on getting up saying good morning. One of these days, your head might be like mine, right? But that's just keep on waking up saying good morning, okay? You got a long way to go. Where them people been, where you going, they already been. They looking through the rearview mirror. They telling you what's ahead for you, right? You probably saying, oh, they old fogey, they don't know what they talking about. We got some new stuff going on. Your hair's braided, right?
Yes, sir.
They was braiding hair back in my day. They was braiding hair before my day. So what I'm saying to you is that there's nothing new under the sun. What you going through, they've already been through. And if I was you, I would take some time to reevaluate my thoughts. Okay? And whatever opinions that you have of your parents, they may not be the right ones if they're bad opinions. Okay. They're doing things to help you because they love you. And as I mentioned to you earlier, they're here because they love you. Them friends that you have today, you ain't gonna have them tomorrow. 10 years from now, you ain't gonna know where they at. They ain't gonna know where you at. They ain't gonna care where you at. Because they're gonna have a new set of friends, you're gonna have a new set of friends. Right? But you won't have a new set of parents. They're gonna always be there for you. Okay. So you ought to thank God that you have parents like that. Everybody don't have parents like that, but you're blessed. And you need to count your blessings. Okay. So you can put all of this behind you, but it's up to you to do that. Okay. So I think you need to get that lady that's here today. You need to give her a big kiss on her cheeks. And you need to hug that man that's here for you too. Because they're the ones that putting aside everything for you. They have your best interests at heart. Okay. And like Judge Davis used to say, potatoes. You think about that. All right? Just think about it. And I guarantee you, when you, after all is said and done, you're gonna look back and realize the blessings that you have. All right, you can stand in front of the court coordinator. And folks, thanks for coming down here with your son. Like I tell people, don't give up on him. I was young at one time. I didn't do everything I was supposed to do that my parents wanted me to do, right? But I'm here today. And thank God for people like you. Okay. And just continue now. I tell people, hang in there. Hang on, don't hang up. Stay with it. He'll get there. You know, sometimes it takes some people a little longer to get there than others. All right. All right. Y'all have a blessed day. All right. All right. Chief. Okay. Okay. Who we have? Do we have, is Brandon Lee Holloway? Who is that? Mr. Holloway? What are we, Mr. Holloway, would you come forward? What are we doing on Mr. Holloway? You have? I had, this is a waiver.
I didn't get it.
Oh. You wanna, won't you have a seat next to that young lady right there? His name is Brandon Lee Holloway. Brandon is his first name. Hey, Mr. Really? Would you come forward? Is that it? I see another, somebody else sitting back.
Jeff, you need to send it.
Hmm?
It's still showing that you have them.
Yeah, I see a couple of people I don't have paperwork on.
Please, I can.
Recently, I got one.
So your information report.
No, thanks.
I see, okay, who is here? Who else is here for, oh, no, yeah. I see it. I see it. I just recognize. Yeah. And it states that this is cause number 23 CCCR 1384, case of style of state of Texas versus Carbon. Is that Jade or JD?
Jade.
Jade. Okay, Jade, really. And Mr. Riley, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. Now, Mr. Riley, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes, sir.
I mean, come on.
He hasn't changed.
He hadn't changed it yet. Okay.
No, we put the paperwork out though.
Yeah, he can scratch through that. You had it on one line, but not the other. And I see you have your mother here with you?
Yes, ma'am. I mean, yes, sir.
Okay.
This one.
No,
Above right here.
yeah.
Okay, now, Mr. Riley, okay. You place your signatures on a line that states you'd like to apply for court-appointed attorney, is that correct?
Yes, sir.
I also have a document that is titled Jefferson County Affidavit Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Riley, before you signed and initial all of these documents that I just showed you, did you read the documents?
Yes, sir, I did.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Riley, I read your answers. Based on your answers, you meet the eligibility requirements of a court-appointed attorney for a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Thomas Burbank. Attorney Burbank will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be able to contact Mr. Burbank. Let's see, that's really. Okay, Mr. Riley. Okay, now. Okay, now, uh, remember those bond conditions? Miss Riley,
Yes, sir.
let me see. So you live in Vidor? Okay.
Yeah.
Your source of transportation is your mother or?
Yeah.
You're talking about the DWI.
Yes, sir.
Okay. Now, Miss, what's your mom's name?
Cassie.
Cassie, Miss Cassie?
Yeah.
Miss Cassie, would you please come forward? And I'm gonna go off the record on this. I just need to ask her some questions. I don't wanna Now, Tom Burbank has been appointed to represent you. As I mentioned to you, Attorney Burbank is gonna be given information to contact you. You will give information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. Now, I need to give you some bond conditions. Okay? And we need to correct your behavior, so we're gonna start off with these bond conditions. And County Code Law number 1. And if these conditions makes Jefferson County a safer place for all of us to live, work, go to school, raise our children. So it says, following the return of a criminal information in County Code Law number 2, Jefferson County, Texas, all bail bonds executed for release of any defendant herein or ordered subject to the additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 does not apply. Condition number 4 does not apply. However, condition number 5 does apply. It says that you will obtain and participate in the Spindletop ATAR, which is the Addiction Treatment and Recovery Program. And you will remain drug and alcohol free. That's number 5. You understand those 2 conditions?
Yes, sir.
And you will attend AA-NA meetings 2 times a week and provide proof to the court. I'm going to give you some paperwork with a verification form. When you go to AA-NA, you'll get a sponsor. That is somebody who can mentor you. Okay, they might have had a drug issue in the past and they've come through it and they can help you along the way. You understand that?
Yes, sir.
That condition. And you'll participate at this ASAP program, Spindletop Center, 2750 South 8th Street, Beaumont, Texas, Building C, 77701. You'll be able to get a copy of this. Now, you're gonna have to talk to those folks. They could make some arrangements. I know you do not drive. Your mom working 2 jobs. All right, how old are you?
19.
You out of school?
Yes, sir.
Okay. Seems like you need to be working one of them jobs.
She said he was working.
Yeah, I was. I
Oh,
just recently lost my job, so
Okay,
I'm not used to not working.
okay, well, that's good. That's good, that's good.
Next month, so he's like.
Well, that's good. That's a good thing. Okay. Okay. Now, yeah, we're gonna make a copy for him. That's my original. And now oh, let me give you this. There are locations in our community that you can go to for the AA-NA meetings. They have them all times of the day. So it's not like it's only one place you can go. And they have them in your town as well. Here you go. Now you're gonna bring that sign-in sheet. Every time that you come back to court, you're gonna bring that sign-in sheet so we can verify that you're in, that you are participating in the AA-NA meetings, okay?
Yes, sir.
All right. Now, hang in there with him. I know you're hanging in there, but just be patient, okay? Yeah, just be patient and you have a blessed day. All right, just, stand over there by the bailiff. Once you get your paperwork, you're free to go and you have a blessed day. Huh? On which one?
Yeah.
Oh, you sent them back to me.
I sent him back.
Somebody sent them back. Pachuca, yeah. So,
And I did see you call.
oh, I see why. I never signed them.
Oh.
Yeah.
Holloway is ready.
Mr. Holloway, you can come forward. I just sent that one back. I'm pulling up Mr. Holloway's. Mr. Holloway, your full name is Brandon L. Holloway?
Yes, sir.
Mr. Holloway, would you please raise your right hand? Mr. Holloway, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Holloway, you may put your hand down. How are you doing, Mr. Holloway?
I'm okay.
That's good. Now, Mr. Holloway, you have a right to have a record made by the court reporter. You also have, she can type down everything that's been said in this proceeding. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes, sir.
Okay, Mr. Holloway, I have before me a document on my computer that is, well, this document on paper is titled Judge's Explanation of Rights and Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have a document that is titled Jefferson County, that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding Trial. You recognize this document?
Yes, sir.
Is this your signature on the line?
Yes,
It's titled Defendant. Before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Mr. Holloway, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Brandon L. Holloway, on or about November 16th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Mr. Holloway, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Holloway, how do you plead?
No
Guilt,
contest.
no contest? Now you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Correct.
Mr. Holloway, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials in 2 locations. First set of initials is below a paragraph that's titled Waiver, and it's on a line next to a box that's checked no contingent, which means no contest. You place your initials on this document.
Yes, sir.
The second set of initials are below a paragraph that is titled Discovery Admonishment, and is next to a statement that reads, I do not request the discovery of the evidence. I waive my right to discover evidence in this case, and I choose to enter a plea of guilty and no contest. Did you place your initials in the second location?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification, the defendant's right of appeal, you recognize this document.
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Holloway, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes.
Okay. Mr. Holloway, Mr. Holloway, are you a citizen of the United States?
Yes, sir.
State Officer 6-1.
Okay, Mr. Holloway, no objection, State's Exhibit number 1. Well, Mr. Holloway, the state is offering State's Exhibit number 1. State's Exhibit number 1 is this first document on the tablet that I showed you, that you acknowledged, same document, have the initials in these 2 locations. And it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
No objection, State's Exhibit number 1 will be admitted. Mr. Holloway, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Mr. Holloway, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do.
And what is the agreement?
In exchange for defendant's plea, the state's offering 6 days in the Jefferson County Jail, credit for time served, tax and return all.
Mr. Holloway, the state is offering that you serve 6 days in the Jefferson County Jail, but you will not have to serve any more in the Jefferson County Jail because you already served 6 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has paid it off. Therefore, the court costs will be taxed and retired. Mr. Holloway, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Holloway, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Holloway, this will conclude your case. You will stand next to the bailiff at the end of the counter, follow her directions. Once you finish following her directions, you'll be free to go. And you have a blessed day.
You too.
You're welcome.
No, that's fine. I'm ready to get out of here. Diabetes been here since 8:30. I'm currently on the signature.
No.
Okay, I'm done.
Yes, sir.
Good thing, yes, you may. This is, let's see, the court is in session in cause number 24 CCCR 1408, case of South State of Texas versus, is that Quindarian?
Yes, sir.
Quindarian Carrier? Mr. Carrier, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Mr. Carrier, you may put your hand down. How are you doing, Mr. Carrier?
Good.
I'm doing fine, thanks for asking. Now, Mr. Carrier, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have a document. This just don't add up right. That's titled Jefferson County Affidavit of Indigence. Now, I also have, I have a document that's titled Jefferson County Affidavit of Indigenous. You recognize this document?
Yes, sir.
And is this your signature on page 2? Above the line is titled Defender Signature.
Yes, sir.
Now, Mr. Carey, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
I appointed Burbank on Raleigh, right?
Yes, sir.
Okay, now, Mr. Carrier, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Reuben Cartwright. There he is. Mr. Cartwright will be given information to contact you. And you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat. Will you please stand in front of the court coordinator? Let's see. Got some bond forfeitures, huh? Hmm? Yeah, hold on a minute. He has Quindarian. Here you go. Now, on our bond forfeiture, we have clause number 25 CCR 0246, case of South State of Texas versus Van Derrick Edwards.
No, that was reset.
That was reset? Okay.
Would be.
Is that Jamie or Jaime Salas Mercado?
No more information to confirm. Address, maybe a bit off too.
No notice.
I could, I mean. If we
Byron Williams. This is cause number 25 CCCR 0442, case of the state of Texas versus Byron E. Williams Jr. Byron Williams is scheduled to be in court this morning at 9 a.m. At about 9 a.m. Of course, be able to call the name of Byron Williams at the courthouse door. Byron Williams did not answer. It has not appeared in court since the court has been in session. The time now is 12:54 8 p.m. on today's date of April 22nd of 2025. Ms. Bailiff, would you please call the name of Byron Williams at the courthouse door?
Byron Williams.
Okay, Byron Williams' name was called again at the courthouse door by the court's bailiff. Byron Williams did not answer. Reasonable time has passed to give Mr. Williams an opportunity to appear in court. He has not appeared in court state. Do we have a motion? That motion will be granted. Byron Williams' bond will be forfeited. Warrant should be issued for his arrest in cause number 25 CCCR 0442. And this will conclude the calling of the court's initial appearance on Rayma docket on today's date of April 22nd of 2025 in County Court at Law number 2. The court will be in recess till 1:30 this afternoon to reconvene with our trial.
Okay.
Which one is that? Okay.